guidance in the ways that we are trying to lead our lives in a way that would be better. And so I'm grateful for that. We have this is being recorded, so I want you to know that when we have a little discussion later on, that while this is not going to be broadcast, it might be accessed by students or others at a later date. So just to be aware of how we're gathered, not just in this room, but beyond this room as well. I also want to acknowledge and express my feelings of what's happened over the past evening with one of our students from the law school getting arrested, and how hard that's been for me and for us as a community. And I know that there are different ways that we're situated in relationship to what's been happening with Coastal GasLink and governments and with Wet'suwet'en, but it's never something to celebrate, and it's something to, in fact, mourn when one of our students has had their liberty restrained. And I'm grateful for this moment to take and think about the personal cost that's being borne not only by Saul, but by many people in this room and people beyond. And I want, if that comes forward, to help you understand, I feel what's happening, and I'm here with those feelings, even though I'm going to be talking in other ways as well. I also want to just mention one of the concerns I've been expressing more broadly is with COVID-19, the potential challenges that not only lie within our student body, how we need to be attentive to the advice that we're getting around watching ourselves and self-isolating if necessary, if it comes in our direction. Also the advice that's being given to seek medical attention in accordance with those outlines that are there. But I'm also thinking about this issue because you may know that Indigenous peoples suffer a great deal of historic trauma around epidemics and pandemics. It was just a couple of years ago when SARS was around that instead of sending kits to our communities, in some places they sent body bags. And it's been many years that people have had tuberculosis in great numbers within Indigenous communities and suffered high mortality rate. And that goes for the Spanish flu and smallpox and other types of diseases that all people face. But when you live with the trauma of that in your own land, and you're living in small, close quarters in many of these reserves that have multi-families, 15, 16 people gathered under one roof, the chances for spread are great there. And we also know that Indigenous peoples fall between the cracks of federalism. And so sometimes the federal government doesn't quite get there in time, and sometimes the provincial government's work doesn't reach quite that far. And so while all of us need to be concerned about this, I do hope that the word is also put out that in the way we're governing ourselves in this country, that there is a danger that Indigenous peoples could also be highly affected by this COVID-19, which is to say that what we're going to be talking about today occurs within a constellation of events that have to deal with recovery from residential schools and child welfare and over-incarceration of Indigenous youth and young folks in court and in jails, and lower employment, the higher unemployment and the lower educational attainment. This is a piece of a broader picture. So I'm going to dive into this piece now, and I'm going to come back to these questions at the end. But these are some of the questions that have been fielding over the past couple of months in the words of reporters as they bring them to me. That is, who are the Wet'suwet'en? What's the difference between them being recognized as a nation and then having title? What's this idea of the rule of law? How can you talk about that in the context of this dispute? What's the issue of injunctions? How does that work through these questions? What about the United Nations Declaration on the Rights of Indigenous Peoples? How's that part of our discussions? The right of free, prior, and informed consent that comes under that document, and now legislation, and what is the relationship of ethic to vetoes. And why are we dealing with this now when we had a Delgamuukw decision 23 years ago that reportedly recognized that the title and rights holder for the lands was the hereditary chiefs, and over 250 years ago we had something called the Royal Proclamation of 1763 that said lands are reserved to Indians. When the Crown comes along, they are to remain in their possession until such time as there's a public meeting called for that purpose, which would either share or transfer those lands. So why are we dealing with this now when we have a 250-year history as well as a 23-year history from the Supreme Court of Canada? What is the significance of the recent agreement between the federal and provincial ministers in relationship to the Wet'suwet'en hereditary leaders? And there are things being overlooked. You might add your own questions. I do hope to be able to field questions here so that we can have a further and deep-bringing understanding of what's going on in this dispute. But we also need a little bit of facts on the table, and so this is the Wet'suwet'en lands. You can see that these lands are organized into different clan groups with these different colors there, and it's a huge area of land. And these clan groups are then, so these are the clans up top here, and here are the clans again. And then within each one of these clans, you will have all of these house groups. And the responsibility for governance is divided between clans and houses. I'm not sure of the exact division of labor in each of the particular instances. But like confederacies or like federalism, you have checks and balances, you have a diffusion of authority to ensure that people are protected through that diffusion. And so these are what are called Wet'suwet'en houses, house groups. And these house groups fall under these different clans. And the Unistoten people, who are occupying a checkpoint as a blockader from this dark house as a part of their relationships within this broader governance system as it relates to the land. These names are passed along in feasts, and I'll just outline for you what was said at the beginning of the Delgamuukw trial, which was the case that eventually went to the Supreme Court of Canada, talking about Gitxsan and Wet'suwet'en titles. It says, for us, this is their opening statement, the ownership of the territory is a marriage between the chief and the land. Each chief has an ancestor who encountered and acknowledged the life of the land. From such encounters come power. The land, the plants, the animals, and the people all have spirit. They all must be shown respect. This is the basis of our law, they say. The chief is responsible for ensuring that all people in his house respect the spirit in the land and in all living things. My power, this opening statement is creating, is carried in my houses histories, songs, dances, and crests. It is recreated at the feast when the histories are told, the songs and the dances performed, and the crests displayed. With the wealth that comes from the respectful use of this territory, the house feeds the name of the chief in the feast hall. In this way, the law, the chief, the territory, and the feast become one. By following the law, the power flows from the land to the people through the chief using the wealth of its territory. That statement was given way back in 1994 as the 1987 as the case was going through trial. So this is their political and legal organization. It's a parliament, it's a legislature, it's a property registry house, it's a court, it's an administrative tribunal, but so much more than what the analogies that we might draw on from the common law might be, but they do have those elements as a part of how they're gathered. In addition to these hereditary leaders, you also have 6 Indian bands within the territory that are outlined here. And these bands were created through the Indian Act, which was passed in 1876, which was designed to wipe out this kind of system and assimilate people into a Victorian, that is a 1870s landholding, understanding, and elected mayor and council type of a way of proceeding. And the authorities that they can exercise under the Indian Act on the smaller reserves, so little postage stamps throughout this territory, are also exceedingly limited. And these limited authorities, up until the 1960s, needed the approval of an Indian agent that was appointed by Ottawa in order to bring that law to Ottawa and have it be approved. And it was only in the 1960s that those Indian agents were removed, but the final approval for authority that the band councils exercise often still remains in Ottawa through the Minister of Indian Affairs having that say over what the scope of that authority might be. Having said that, you have a movement back and forth between some of these hereditary leaders at the clan or the house level and into the band level. So some of the chiefs or councillors in these communities might have been the plaintiffs who are hereditary chiefs under the Delgamuukw case. In fact, that is the case in some instances. So, they fought, stood on blockades for decades and decades before going to trial up to Supreme Court to try to get their rights recognized under this fashion. But then they've also, at another point in their career, turned to try to exercise some measure of responsibility through these systems as well. And there's 5 of these bands that have signed agreements with Coastal GasLink as the pipeline runs from the Dawson Creek area into the Kitimat area. And you can see that the pipeline runs through a big portion of Wet'suwet'en territory. If you break that down even further, you can see where some of these bands are that are Wet'suwet'en bands that have entered into an agreement with Coastal GasLink to help provide jobs and experience through training, and also to provide infrastructure in the community. So school programs, school buildings, language revitalization programs, economic development, obviously. And so there's this elected system that is uncomfortably, to say the least, interacting with this hereditary system. Now, what's important to note is that when the Delgamuukw decision was decided and subsequently followed up by the Silcotin decision, the authoritative government in the area for holding title and dealing with the resource and other rights is actually this government. The Supreme Court of Canada said this is the body that you would enter into agreements with in relationship to that entire territory. But as you can see, there's also been something on, because these are the bodies that have historically been recognized by the Canadian government, and these bodies have not been recognized by the Canadian government up until about 3 days ago, when Minister Bennett and Minister Fraser were up at the Smithers area negotiating for that kind of a recognition. So we went through, like 150 years of this, but this has been on the ground for thousands of years, and only in the past few days has recognition come about in relationship to these folks. Here is where the Unistoten camp is in relationship to the checkpoints and where the blockades are happening on the land, and this is where the biggest flashpoints are in the territory. if we put this into the broader legal history, these folks regard themselves as being created in this territory. The archaeological record is very deep, 12, 13,000 years. This social organization, this structure has been ongoing for millennia. These are Athabascan-speaking people, which are part of what's largely sometimes called the Dene-speaking people. They are in the Mackenzie Delta. Dene or Athabascan-speaking people are. They come down through the Mackenzie Delta into northern British Columbia and northern Alberta, and then they continue further south. There's Athabascan-speaking people in Alberta, and then the Navajo Nation in the deserts of the American Southwest that has a reservation the size of North Carolina is also a Dene or Athabascan-speaking people. So they have long relationships and presence, and they developed their own social organization distinctively as Wet'suwet'en people from the Navajo or the Tlicho or other Athabascan-speaking groups that might be there. In 1822, Hudson's Bay trader came into the territory. His name was William Brown, and he described these folks as men of property and possessors of land who regulated access to their territory through a structure of nobles or chiefs, commoners, kinship arrangements of some kind, and priority relating to the trapping of beaver in the vicinity of these villages. And then in 1923, he wrote in his journal, "These chiefs have certain tracts of country which they claim an exclusive right to, and will not allow any other person to hunt upon them." It was very clear from the first moments of European contact who the owners of the land were and how they were attempting to assert their own relationship to that land and ensure that others would not impinge on that land without their permission. Skip Ray, Arthur Ray, a professor at UBC, wrote in his expert report for the Wet'suwet'en case, when the Europeans first reached the Middle and Upper Skeena River in the 1820s, they discovered an area that was settled in a number of relatively large villages. The people subsisted largely off of their fisheries, which in about 2 months of work per year allowed them to meet all of their food needs because there was so much protein that came into their territory through the salmon runs. Summer villages were located beside their fisheries. Large game and fur bears were hunted on surrounding and sometimes on more distant lands. Hunting territories were held by nobles on behalf of the lineages they represented, and these native leaders closely regulated the hunting of the valued species. These various villages were linked into a regional exchange network, and indigenous commodities and European trade goods circulated within and between these villages by feasting, trading, and gambling activities. 1846, Britain asserts its sovereignty over this territory through the Oregon Treaty as the line between the United States and British North America moved up from the Columbia River to the 49th parallel. And with that assertion of sovereignty is the implication that that land now becomes the Crown's land, at least in terms of the underlying title to that land. This idea of a doctrine of discovery presumes that the people that are already in possession there have some kind of lower level of social organization and legal organization in relationship to the land, which is problematic to say the least. There are a bunch of Crown proclamations and ordinances that are then given that say to folks from around the world, come settle here, come mine, set up agricultural opportunities, take the trees off of the land. And all of this occurs without any treaty, any agreement, any permission on the part of those that are there, and of course were there upon that arrival. Part of these proclamations is that if settlers moved into this land, they could set up a house and clear a few acres, and then they could go down to the registry office and get title to that land through what's called preemption. This preemption process was not open to Indigenous peoples. So not only did they not recognize that Indigenous peoples were the owners of the land, which the Royal Proclamation of 1763 should have recognized, as that policy follows the flag of Britain as a Magna Carta, but even in the particular instances of how land was allocated, this occurs to say you're not allowed to preempt as the other settlers are around you. When British Columbia came into the Union in 1871, there was a revision there that said that British Columbia and the federal government would pursue a policy as liberal as heretofore pursued. It's thought that Canada, Crown and Right of Great Britain, understood that there was treaties happening throughout the territory, because there was some Douglas treaties that took place here on Vancouver Island, but that wasn't happening. And so when this got in the hands of British Columbia politicians, the terms of union say that we will follow a policy as liberal as we have hitherto followed, but their policy wasn't very liberal. And so up until the 1990s, there was a denial of Aboriginal land rights, title, resource rights, and voting rights were taken away or not even extended to Indigenous peoples, although they were the majority of the population in the 1870s. They might have been about 40 to 70,000 people. They were not bestowed the franchise. About 10,000 people living largely in the lower mainland here were given that right to vote. And so then the laws started to be created in a way that cut out the pre-existing owners of the land. All through this period, the Wet'suwet'en engage in political advocacy, but as they do so, there's a criminalization. And so in 1927, the Indian Act was amended to make it illegal to consult lawyers for the purposes of land claims, to pay them, to gather in groups to try to advance that idea. And so Aboriginal title, although the people were there with these relationships for millennia, was definitely marginalized. In the 1980s, the Constitution was patriated, Aboriginal treaty rights were put in there, and then in 1997 you get this case emerging from the Supreme Court of Canada, the Delgamuukw case, that says if you had occupation prior to the assertion of sovereignty, and you can show a continuity of that occupation, and it's exclusive, meaning the Gitxsan are separate from the Wet'suwet'en, or they have a relationship when there's an overlap, then they can prove title. And in fact, the test in Delgamuukw set that out and teed it up for the hereditary leaders to be able to be the recipients of that title, but then it was to go into negotiation, and negotiation broke down. As you know, in 2014, the Silcotin case was decided, and another group was able to succeed on this test through their hereditary legal structures. What the content of that title is it's unique because it's not just formed from the common law, it's also formed from Wet'suwet'en law or Silcotin law, and so that law has to be applied as a part of what the content of the title would look like. And the court in Delgamuukw and Silcotin said when title is proven, it's not limited to traditional activities. And so they in fact mentioned that they have all their subsurface rights and the subsurface rights in that soil, including oil and gas. And so with that broad fee simple-like interest in the Silcotin instance, the Crown no longer has in that area title. Crown title. No, there's no beneficial use that the Crown has over that land once Aboriginal title is recognized. It's possible to put a regulatory use in relationship to that land that might involve some use of that land if you can justify an infringement of title down the road. But for the most part, it's a very broad interest with an inherent limit, which is that people cannot destroy their relationship with that land. Now, in December, the injunction was issued by the British Columbia Supreme Court to insist that the Unistoten vacate their blockade of that territory, and it had that blockade there for many years. It has a healing camp associated with it. The court said, as a general rule, Indigenous customary laws do not become an effectual part of Canadian common law or Canadian domestic law until there's some means or process by which Indigenous customary laws recognize as being a part of the Canadian domestic law, either through incorporation into treaties, court declarations such as Aboriginal title or rights, jurisprudence, or statutory provisions. And the court said there's been no process whereby Canada has recognized that ongoing occupation, use, and governance of that territory, and therefore there is no basis for taking into account Aboriginal title in issuing the injunction, because it's not been received by Canadian law according to the court there. Paragraph 138 of the opinion says the defendants are posing significant constitutional questions and are asking this court to decide those issues in the context of an injunction application with little or no factual matrix. This is not the venue for that analysis, and those are issues that must be determined at trial. So what an injunction does is it tries to preserve the status quo. And the status quo has not recognized Aboriginal title, and so those folks on the Unistoten checkpoint are the ones that are asked to vacate, and the injunction cannot do anything to say Wet'suwet'en people here, they have title in the court's own view. I think that law happens to be wrong, but in the court's own view, that's their reasons for not for issuing the injunction. I have a colleague, Mark Haddock, who used to teach here in the Environmental Law Center, and he questions the appropriateness of using injunctions to be able to address these questions. They're interim, they're a generalist, they're very blunt tools, and some of the answers I've been trying to give to reporters is if you think about injunctions in the labor context, we had decades and decades and decades of unrest between labor and management, and eventually we got rid of injunctions in this jurisdiction because we said that's not getting at the problem-solving point. It's just sort of really enforcing the power that's already there, which in that case, management often had more power at law than labor did. And so we now have a system of mediation, and then mandatory arbitration, and then maybe there's some fact-finding by a labor commissioner body. Or then maybe it will go into administrative tribunal here. We have all sorts of possibilities in other contexts where you can start to explore the nuances on the ground. We don't have that in this area. Injunctions are blunt tools, again, that don't have this specialized court or tribunal or body that might work for this in more productive ways. I published about these ideas of blockades and occupations in a book that came out in 2016, because in the beginning of 2000s there was a blockade at Ipperwash, and a Anishinaabe man, Dudley George, lost his life. And I looked at blockades and occupations from coast to coast to coast over 150 years, and I came to the conclusion in 3 categories. Sometimes they work, sometimes it's ambiguous, and sometimes they fail horribly. And the idea of using direct action is the idea that it depends. You always have to be paying attention to the context, which shifts under your feet as you're trying to engage in direct action to make your points known. I like this quote from Gene Sharp: "When people refuse their cooperation, withhold their help, and persist in their disobedience and defiance, they are denying their opponent the basic human assistance and cooperation which any government or hierarchical system requires. If they do this in sufficient numbers for long enough, that government or hierarchical system will no longer have power to a certain degree." We know about Gandhi and Martin Luther King and other folks across time and space that have used civil disobedience to try to invert the relationships of power and show what it might feel like to have your mobility be restricted as a dominant group in the way that Indigenous people's mobility is often restricted because of the failure to recognize governance and titles and laws, etc. But I also raise a caution about always valorizing civil disobedience and direct action, because we have to go back to the preemption process. The preemption process was set up by settlers largely through direct action, walking into Indigenous territories and taking over their lands by building houses and clearing areas for agriculture. Most of British Columbia has been settled through civil disobedience. Disobedience to Canadian law, the Royal Proclamation of 1763, which says this land is reserved to Indians until such time as there would be a process, a treaty, to turn it over to others. So civil disobedience works, but it might not always work in the way that we hope or think, and it can be a tool in other people's hands as well as Indigenous people's hands, and part of the conclusion in that book was trying to take that into account. My views, constitutionally speaking, everything is there to recognize Wet'suwet'en title. Maybe that's what that agreement does between the ministers, and then recognize Wet'suwet'en jurisdiction in relationship to that land. And with that recognition then would be a recognition of an internal dispute resolution process that would allow those elected leaders to have discussions with those hereditary leaders, and through their own systems figure out how they're going to work in the future in relationship to that land. Because one day it's likely going to be the case that that's going to be Aboriginal title land. And if it's Aboriginal title land, then the question is, well, how did the pipeline get there? And is the pipeline something that can be supported because the Crown gave something that it didn't actually own? If you give something to someone else that you don't actually possess, there's a question mark on that title. And so these folks need to figure out in-house how their laws operate, including their abilities to disagree with one another, which any community needs. There's always going to be a diversity of opinion within First Nations, Métis, and Inuit communities, as there is in the wider population. We have majority judgments and dissenting judgments. We have majorities in Parliament, and then third parties and official oppositions. We have this different schools of thought, and that is part of what we have to, I think, wake up to, is that Indigenous peoples have the right to be different from other Canadians on a political, on land basis, but they also have a right to be different from one another. And that right to be different from one another is something that requires their laws to be applied in those instances. And then we need those intersocietal dispute resolution mechanisms through negotiation, which this new legislation in British Columbia would allow, with UNDRIP implementation, or through sui generis Section 35(1) processes, or opening spaces for Indigenous peoples in federalism. Tried hard, that was half an hour. Not a lot of time for questions like I'd hoped, but we do have 10 minutes or so. Observations, things that you might want to identify or talk about that might not have been posed in this presentation. Okay, let me take this point then, which is, what is the relationship between free, prior, and informed consent and Indigenous nations' ability to veto projects? Free is having information and ability to make decisions that's not coerced and is not under duress or not under compulsion. And that's how Indigenous people should be able to make those decisions in relationship to development in their territory, without coercion, without compulsion, without duress. Prior means they can't just get word at the last moment. They have to be there at the beginning as the proposal is being floated to decide whether or not they want to participate in that proposal and the degree to which they would like to, if they do, or also that they don't want to participate in that process. And so that's the prior side of things. And then informed is that they have sufficient information that would enable them to make a decision that is not done with things being hidden in dark corners. There is a fiduciary duty that the Crown has to Indigenous peoples not to hide information. That's the Garand case when it affects their interests. But corporations also have to be on that same page, because the Crown cannot delegate ultimately away that authority for consultation and accommodation. It's the corporations that actually do the job of trying to figure out what's happening there, but the Crown has the final word. So, if you go through this process and a First Nation says no, especially in a title context, as in the Silcotin case, then it likely means that that project cannot occur. And so consent does mean the right to say no, and it has to be a part, a big part, the biggest part of this process to have it have any meaning, have it have any legitimacy or authority. Yet, it is also possible that a group in some instances might say no, and because of the Section 35(1) framework, there could be a justifiable reason for infringing that title, and the Crown would have to fulfill a very high duty of consultation, which would substantially address their concerns. But it is the case that even if they do all that and they still utter a difference of opinion, if it's in those broader public interests that Section 35(1) infringement allows, that development might be able to go ahead. I have a lot of critique of that. I'm just stating the law as is at this moment. But it does get at the point that rights are relational, and that no right in the world is absolute. And even under Wet'suwet'en law, or certainly under Anishinaabe law, the rights there, the obligations, the entitlements, the laws that we would have to one another would not be absolute. And so the fact that there's not a veto there might just be to say that we live in a world where we are entangled and enmeshed, and unfortunately, we don't talk about power relationships in that context. And we're often allowing those that are most powerful to set the agenda and the possibilities for taking up land, and those that are most vulnerable are not able to have their points recognized in those settings.
The one above, the implementation of UNDRIP. I'd like you to talk about it in the context of what I call the customary right of self-determination. I think this is one of the most exciting developments in Canadian legislation history, and I wanted to know what your views were in terms of what self-determination actually means and how we're going to develop that work.
So there's 46 articles in UNDRIP, and they're premised around this idea of self-determination for social, political, economic, and other factors. And that draws on a customary international law, as we've been working over the past 30, 40 years for Indigenous peoples to be the decision makers for their spirituality, for their land, for their relationships. And so that, through the legislation, there's now a provision in one of the clauses to use all of those articles and then recognize Indigenous rights in relationship to that declaration. Just one more question.
Yeah, thanks for the time. When I'm engaging in conversations with DJIU students, I'm always confused as to why the concept of rule of law is looked upon negatively. And I'm always confused. Because the way I learned rule of law in common law is that it's a good thing, because before that it was rule of king and whatever he decided that day. To have rule of law is good. If we have bad laws, we've had it throughout history, and there are good laws, so why is rule of law
great? So this is a great question to take up our final 2 minutes, because then we have to vacate the room. So part of sometimes people's challenge in that is the rule of law is actually the rules that kicked people off of their land and prevented them from having their children and enjoying their relationships to economies and spiritualities and whatnot. So rule of law has not been a neutral thing. It's been quite targeted to help some people and not other people. But I do agree, rule of law can be framed more broadly. Rule of law is about not having arbitrariness in your relationship. and without being arbitrary, then understanding what the procedures and principles are that allow us to be ordered and patterned in a way that we can predict and hold people to accountability around that predictive function, and then have transparency in that. So I think the rule of law can be talked about in a positive light. What sometimes happens is that people talk about rule of law as the enforcement of the injunction. And they say that's the rule of law that we need to enforce. But that doesn't see the fuller picture, which the rule of law includes Aboriginal title. The rule of law includes UNDRIP, under now British Columbia legislation. The rule of law includes that community-based policing might be one of the ways that you enforce an order of the court. That it's not always necessary that you take people into handcuffs and imprison them, but the police have a lot of things. So the idea of the rule of law is to see the principles and the processes in a broader relationship to one another. And if that is the rule of law we're speaking about, I'm in favor of that. I can think of many good reasons for using that way of proceeding in the world. If it's the rule of those that are more powerful without transparency and accountability, then that's not the rule of law. And it's certainly not the vision that I think we're here to learn about, which is to be persuasive with one another. Law is not just about force, it's about reason. And that's why we go through case after case after case, trying to understand those reasons and find places where we can maybe disagree with one another, but disagree in an agreeable way. Because we have patterns there, we have orderly opportunities to deal with these challenges rather than the blunt tools that are on display in the last couple of weeks. Thank you for your attention and being